Welcome back to Financial Literacy for Lawyers, Bridging Law and Business. I'm Professor Seth C. Oranburg, and in this episode, we'll explore where financial statements and securities law intersect. This is where the numbers in a company's reports become statutory obligations, where federal enforcement comes into play, and where there's substantial personal legal risk. We'll explain how and why financial disclosures matter far more than just for the accounting department, and what every legal professional should know about the stakes. I hope you're seeing these pieces connect because if you are, you're gaining an edge. Most lawyers don't see how finance matters, and we'll keep advancing that with a practical and focused session. Today's not going to make you a securities expert, but you'll become more aware of how the numbers tie to compliance. As always, this podcast is for educational purposes. For specific legal advice, consult a professional. Securities laws in the United States, such as the Securities Act of 1933, which governs offerings, and the Securities Exchange Act of 1934, which oversees ongoing reporting, makes transparency about a company's financial health a matter of federal law. Whenever a company raises capital from the public by selling stocks or bonds, it must disclose truthful, up-to-date financial statements with key business risks, management biographies, and compensation revealed. These disclosure requirements serve as the backbone of the U.S. regulatory philosophy. Investors can't negotiate directly with issuers in public markets, so the SEC enforces rules to ensure information flows freely and accurately, leveling the playing field. The SEC, as chief regulator, scrutinizes filings to protect markets, turning your client's balance sheet snapshot, income statement movie, or cash flow behind the scenes into a public document, basically under oath. Think of it as elevating internal reports to evidentiary status in potential litigation, where you might have the United States on the other end of a V, where omissions can be as damaging as falsehoods. So let's talk about what must be filed. Public companies file regular reports with the SEC, most notably Form 10-K, which is a detailed annual report with audited financials, business discussions, risks, and management's analysis of results and liquidity. There's also Form 10-Q, which is a quarterly update with unaudited but reviewed financials covering the other 3 quarters, and Form 8-K, which reports major events like bankruptcy, control changes, fraud discoveries, or new hires. And these have to be issued within 4 business days. Information reported must follow generally accepted accounting principles, or GAAP, GAAP, in the U.S. And if you're filing elsewhere, other standards like the International Financial Reporting Standards may apply. And this ensures consistency and comparability. Missing deadlines or incomplete filings can halt offerings, invite comment letters, which are SEC requests for clarification, or worse, enforcement actions like cease and desist orders. For lawyers bridging law and business, these aren't just forms. They're compliance checkpoints where financial misstatements become legal violations, potentially triggering investigations if inconsistencies appear. So what are the liabilities for missteps? Disclosure is not just investor protection. It's a primary legal risk for directors, officers, auditors, and their advisors, like their lawyers. False or misleading statements in offerings or reports can lead to SEC enforcement, fines, bans from industry roles, private lawsuits for damages under laws like Section 10B of the Exchange Act, or even criminal charges if fraud is proven with intent. Auditors and legal advisors are gatekeepers. They face personal liability if they enable or even miss misleading information, as in the PCAOB's March 2025 fines totaling $3.3 million against global KPMG firms for audit failures involving undisclosed participation of other accounting firms. The key concept is materiality. The question is, would a reasonable investor care about this information? Cases like Basic versus Levinson from 1988 held even preliminary merger talks can be material if they impact decisions, and established the fraud on the market theory, where reliance is presumed where we have efficient markets. The case involved Basic Inc. denying merger talks while it was negotiating, denied they were happening, which led to shareholder suits after the deal was announced. And the Supreme Court affirmed that materiality depends on probability and magnitude. In Halliburton, 2014, the Supreme Court preserved fraud on the market theory but allowed rebuttals with price impact evidence at class certification stage, which gave defendants a tool to challenge the reliance prong. This followed Halliburton's argument that no price distortion occurred from alleged misstatements about asbestos liabilities. In 2013, the Amgen case involved alleged misrepresentations about drug safety, and the court held plaintiffs don't need to prove materiality to get class certification. These are just a few cases that shape how lawyers defend or pursue claims tied to financial disclosures, and they emphasize early assessment of materiality. So, materiality is an evolving rule, and it's the core concept here. Again, the question of materiality is whether a reasonable investor would consider omitted or misstated information important in deciding to buy, sell, or hold some security. This undergirds securities regimes, requiring not just numbers but context, including liabilities and risks like environmental, social governance factors that could affect future performance. Recent pushes for climate disclosures reflect this. The SEC's 2024 rules mandated emissions and risk reporting. Securities violations can be consequential or fatal. Failing requirements leads to penalties, delisting, loss of trust, and executive ousters. Class action lawsuits often follow from stock drops and restatements, and staleness or outdated info halts offerings until the information is updated. Cases like Enron and WorldCom showed that there can be billions of dollars in losses and prison terms for manipulated disclosures. And more recently, Nikola Corp's fraud showed founder Trevor Milton convicted of securities and wire fraud for misleading electric vehicle claims, and he was sentenced to 4 years in 2023. He was pardoned by President Trump in March 2025. The company filed for bankruptcy in February 2025 amid ongoing suits. Milton had hyped hydrogen trucks with false demonstrations, defrauding investors of $660 million, leading to his 2022 conviction before the pardon erased it, though creditors continued pursuing him in bankruptcy court as of this recording. Inadequate reporting isn't just a technicality. It's a legal event harming companies, leaders, and professionals who approved filings, often starting with SEC probes into whether the omissions were intentional. In our next episode, we'll step into bankruptcy and financial distress, where a lawyer's ability to interpret numbers can make all the difference between protecting a client's interests and missing crucial opportunities or even committing malpractice. For now, here are some steps to navigate SEC disclosures, with a few points of guidance for your application. The first thing in SEC work is to insist on regular review and internal audits before SEC filings. You want to coordinate legal and financial teams to catch inconsistencies early. The second is to keep close watch on footnotes and management discussions, because risks can emerge from these. Ensure that those footnotes are current and comprehensive to avoid materiality claims. In general, with a public company, you would err toward disclosing more and not less. A third is to make sure statements comply with freshness at offerings. When in doubt, disclose to mitigate challenges, as overdisclosure is safer than underdisclosure. A fourth is for environmental, social governance, or non-GAAP disclosures. Reconcile fully and avoid overemphasis. Again, favor transparency in emerging areas like climate disclosures. Even if rules are paused, you might consider complying with them. And the fifth is, in offerings, build disclosure committees to document diligence to protect against later scrutiny that the duty of care was breached. Meeting minutes can help you as a shield. Next, we're going to talk about bankruptcy. But for now, I hope this session on securities has given you some insight into how crucial it is to have financial literacy when working in all these areas of law. But until next time, I'm Professor Seth C. Orenberg, and this has been Organized.